Congratulations! You have made it this far and are doing a great job. You have done some hard work, and you might feel like you can finally set it and forget it. But I want to offer you a quick perspective shift. A successful estate plan is not a static photograph of your life taken on a single day. It is more like the software on your smartphone. If you never update it, eventually the apps stop working, security gaps grow, and the system could fail right when you need it most. In the world of trusts, we call this silent plan failure. This can include any of the following: outdated trustees, missing beneficiaries, assets drifting outside the trust, old assumptions that no longer match real life. Today, we are going to look at how to keep your plan functional for the long haul. We will look at legal ways to change your mind, some life triggers that should cause you to pull your documents off the shelf to review, and the common mistakes that could accidentally invalidate your entire strategy. Let's start with how you actually make a change. Now, one important aspect to note: most of the changes we will be discussing are only available if you have reserved the right to make changes. Some trusts are written, so they cannot be changed. This is usually the case with any of your irrevocable trusts, so before you try to change anything, check to see if you have the power to do so. Our first option is an amendment, or amending a trust. An amendment is a patch. You use it for small, targeted changes like changing a trustee or successor trustee, updating a distribution percentage, adding or removing a beneficiary, tweaking administrative language. An amendment does not replace the trust. It sits on top of the original document. That's fine, until there are too many amendments. If you need to flip back and forth between 5 documents to understand what the trust says, confusion is almost guaranteed. So what can we do in that situation, or in the situation where the fix needed is more than just a small patch could fix? You might choose to restate the trust. A restatement is a full rewrite, but without starting over. With a restatement, you often keep the following: the same trust name, the same trust date, because the restatement is often indicated in the documents with the words restated on and a date added. All assets already titled in the trust, but you replace all prior language with a clean, updated document. A restatement is usually best when you've made multiple amendments, family dynamics have changed significantly, laws have changed, the trust feels dated, cluttered, or hard to interpret. Here's an important point. Restating is often cleaner and safer than stacking amendments, and in many cases can be more efficient for administration. And because the name and date of the trust don't necessarily change, you don't have to go through the hassle of funding or retitling your bank accounts all over again. It is cleaner, easier for your heirs to read, and it avoids all those old, messy amendments. The third tool is revocation. Revocation means pulling the plug. You cancel the trust and return assets to yourself individually. This may be appropriate when you're going through a divorce and need to split the assets before starting over. You are abandoning the trust structure entirely. You are intentionally starting fresh. But here's the danger. Revocation requires retitling every asset. Miss one asset, and you've created a probate problem, or worse, an ownership mess. That's why revocation is usually the last choice, not the default. So, when should you reach for these tools? There are specific life triggers that should act as an alarm clock for your plan, along with a general rule of thumb that your trust should be reviewed every year, or at least every 2 to 3 years. But some events require immediate attention: marriage or divorce, birth, adoption, or death of a beneficiary, a trustee becoming ill, unreliable, or unavailable, sale or acquisition of major assets, a beneficiary developing addiction, disability, or creditor exposure, moving to a new state, significant tax law changes. And here's something important to look for. If your trust names people who are dead, estranged, or incapable, and you haven't updated it, your plan has a navigation error that needs fixing. Also, look at changes in circumstances with any of your beneficiaries, which may encourage you to move from a simple payout to a protective spendthrift structure to ensure your legacy isn't squandered. And usually, when there is a large change in your assets, think selling a major business or winning the lottery, your tax strategy might need a professional tune-up. However, it also may be the case when you have a change in any of the following: new bank or brokerage accounts never titled into the trust, real estate purchased in an individual name, beneficiary designations that contradict the trust, refinance property that lost trust ownership. In each of these situations, review your documents to ensure your plan doesn't fail. Now let's talk about the mistakes that could ruin your hard work. The most common mistake is the handwritten scribbles. It is incredibly tempting to grab a pen and just cross out a name or write a note in the margin of your original signed trust. Those marks create confusion about your intent. They could require court interpretation to determine what you actually wanted. As a rule of thumb, if you want to change your trust, do it through a formal signed document. Another common mistake is forgetting that you still need a will. Even with a trust, you should have a pour-over will to act as a safety net for any assets you might have forgotten to fund into the trust. And finally, don't forget the power of a crummy notice if you have a specialized life insurance trust or other trust requiring these notices. Missing those small administrative steps could create unintended tax consequences later. By watching this video today, you have already moved from set and forget to active leader. You now understand the difference between a patch and an upgrade. You know the triggers to watch for, and you know to keep your pen away from your original documents. If you're ready for a small immediate step, I invite you to review the questions below this video in the MyEstateKit app, and then glance over the resources to determine how to keep your trust updated. You're no longer just building a plan, you're maintaining a legacy. You're ensuring that your voice remains current, clear, and powerful. You're doing great. Let's keep this roadmap polished and ready for the journey ahead.